Union Station to lunch together during recess. That's just it's an astonishing statement. You know, one of the things that haunted Charles Houston and almost any black person and almost every black man was the indignity of not being able to go into a restaurant like that. It's the stories he told his son. I know his son, late in his life. The idea that it did not matter to Herbert Wexler that he didn't know anything but his sort of imagined view of that issue, it's just breathtaking to me. That's certainly not what an inclusive democracy should want in its judges, and it's not what it should want in its Supreme Court justices. And I think that that concept of neutrality, of the umpire, is in fact antithetical to how I view and how LDF views what a democracy simply has to require of its judges, which is wide exposure to the ideas and mores as diverse as this nation of many peoples.
I want to thank John Payton and turn it over to Stanley Fish for his opening remarks.
Thank you. I want to open by thanking Michael Waldman for leading me here after, all too characteristically, I went to the wrong building. I want to make a few points in a way that will, I hope, invite discussion. First, I will hazard an answer to the question that we are here to discuss. What kind of Supreme Court justices do we want? Well, I want what everyone wants. I want justices whose views mirror mine, and who will likely rule as I would have ruled were I in their place. But were I a member of the Judiciary Committee, no fear of that, I would not approve or disapprove nominees on that basis. I would instead ask myself whether a given nominee was qualified in the sense that he or she had the requisite knowledge and experience to take on the job. That is why, unlike President Obama, I would have voted for John Roberts and against Clarence Thomas, because the former, Roberts, was obviously knowledgeable in the ways of the law, and the latter, at least on the basis of his first set of hearings, was not. But I should add that over the years I have come to admire Justice Thomas. As a citizen, it is perfectly appropriate for me to make a political judgment on this matter. I want this kind of guy or woman. And it is also appropriate for the president to do the same within limits, as represented, for example, by Harriet Miers. But as a Judiciary Committee member, I should be making a craft judgment. That brings me to my second point. The craft involved in doing judging, is a more significant constraint or influence than any theory a judge may have of that task. In fact, I would go as far as to say that the theory of interpretation a judge may proclaim is absolutely irrelevant to his or her performance. Largely because the interpretive theory a judge professes is likely to be incapable of being put into practice. And if your theory can't generate a practice, the fact that you have it is of no consequence whatsoever. Since I dislike it so much I can't even say it, textualists like Justice Scalia say that they decode the meaning of texts by attending strictly to the well-established dictionary definitions in force at the time of the text production. But if, as I would argue, if it is not possible to derive meaning that way, because words do not have meaning and are not even words apart from some purposive design they cannot announce and do not contain, if that is the case, as I am sure it is, then a textualist theory could not possibly generate an interpretation. Whatever she was doing while interpreting, it would not be what she thought she was doing. And it follows that the announcement by a judge that she would be a strict textualist would be of no interpretive or predictive significance, although it would very likely have a political or public relations significance. This argument holds also, with a variation, for those who announce that they are proponents of the living or dynamic Constitution. not because such a stance could not yield a reading of the text, but because any reading generated under the assumption that the Constitution is not a fixed object, but a living, changing organism, would not be an interpretation. It would instead be a product of the decision to abandon interpretation in favor of something else, like forming policy or doing social justice. Point 3. A shorter way to say what I have just said is simply, when judges decide cases, they don't do theory, even in those instances when they invoke theory. What they do, and what we expect them to do, is proceed according to the protocols and obligatory routines of this job and not of another. Of course, even if judges resolve to do that, there is more than one understanding of those professional protocols, and two judges whose understandings differ may well reach different conclusions. It would not, however, be accurate to say of either judge that he or she is winging it or making it up, because both would be proceeding within the appropriate job-specific guidelines of which there are opposing yet legitimate accounts. This brings me to my fourth point and to the vexed notion of neutrality to which John has already referred. Neutrality is a virtue some say Judge Sotomayor will not have. Neutrality, properly conceived, does not mean leaning in no direction whatsoever or being influenced by anything you have ever read, thought, or experienced. Neutrality rather means leaning in one of the directions that are available within the established confines of the task as professionally specified. Now, leaning in directions that do not belong properly to the task are out of the ballpark. Leaning in the direction of a particular party or church or interest group is a violation of neutrality because it leaves the task of judging behind and begins to prosecute another task. And my fifth and final point, in other words, you depart from neutrality when the reasons you have for deciding are not the kinds of reasons recognized as legitimate by the enterprise. A question raised by the Sotomayor nomination is whether reasons having to do with one's background or ethnicity are legitimate reasons. Does what is usually called identity politics have any place in judging? My answer is, it depends. If a judge were to incline this way or that, because one or the other party looked or sounded like her, that would be a dereliction of judicial duty. But if a judge faced with a fact situation calls on experiences and knowledge her brethren may not have, if the case, for example, concerns a young girl or a woman of color, and she has been one and is the other, she is not exceeding the boundaries of the practice, but bringing relevant information to it and thereby improving it. There are two kinds of reasons that might flow from identity. Tribal reasons, he comes from my neighborhood and therefore I'm on his side, and rational reasons. I've been there and let me tell you what it's like. And while the first, tribal kind of reason should be shunned, the second is both unavoidable and honorable.
I want to thank Stanley Fish for his remarks and call on Burt Neuborne for his opening remarks.
Thank you. Let me all welcome you to the intergalactic parliamentary room of the NYU Law School. When I first saw this room, I couldn't believe that we had spent money to build anything this pompous. But the faculty meets here, and it doesn't bring out the best in us. But welcome. A particular welcome on the eve of what I am confident will be the confirmation of Judge and soon-to-be Justice Sotomayor. That's a very special reason for interest for the Brennan Center, because she will assume Justice Brennan's seat on the Supreme Court. Justice Brennan was on the Supreme Court for 37 years. He was replaced by Justice Souter, and Justice Sotomayor will replace Justice Souter and will, I'm sure, continue